We've previously examined the CCRC through the lenses of the Justice Committee, and groups like Innocent failed by the CCRC. But many questions remain unanswered, especially practical ones. How does someone even begin to contemplate making an application? And crucially, is there support available for prospective applicants navigating this complex process? In this episode, we'll explore these questions in greater depth and hear firsthand from an academic who has been studying the real-life experiences of individuals seeking legal representation, and applicants' awareness and experience of the appeal and post-appeal processes within our criminal justice system.
Welcome to Spoken in Justice, where we put the criminal justice system in the dock. Today, we intensify our focus on the Criminal Cases Review Commission, an institution of critical importance as it often stands as the final lifeline for those wrongfully convicted to overturn their convictions. I'm thrilled to welcome Dr Lucy Welsh, a reader in criminal justice at the University of Sussex, co-author alongside Dr Emmy Clark of Brighton University of a new briefing paper titled Applicant Experience of the Criminal Cases Review Commission, released on the 17th of June 2025. Drawing on qualitative interviews and applicants' letters, her work probes how funding constraints and procedural opacity shape the experience of those fighting for their convictions to be reviewed. I'm really looking forward to digging into the methods, findings, and real-world impact of this work. Dr. Welsh, thank you for being with us. It's a real pleasure to have you on the podcast today.
Well, thank you for inviting me. It's great to have the opportunity to talk about my work.
Lovely. I thought before we dive into your recent work, could you start by telling us a bit about your background? What drew you to criminal justice and how your journey has led to this focus on applicants' experiences in the CCRC?
Yeah, absolutely. So a long time ago now, I worked as a defence lawyer for about a decade. And I saw lots of problems that were being caused by cuts to funding and in particular legal aid cuts. And I decided at that time that I wanted to try and research around those issues and the problems that were being created by cuts to the justice system. So I became an academic instead and moved away from practice. And back in 2021, I finished a report that was about the impact of legal aid cuts on appeals, on criminal appeals, but in particular how defence lawyers were responding to legal aid cuts and what it meant for casework. And that kind of led into, well, how are applicants experiencing this themselves? Because we have quite a lot of information about how legal aid cuts have impacted lawyers, but are those same experiences felt by the people who would be the recipients of legal advice? So that's what led me to this project.
That's a great focus. So your project involved 49 interviews across custody and liberty, plus 47 letters sent to the Law Commission. What led you to choose these data sources and what were the key themes you looked for?
Well, so I did the work with a colleague called Amy, and both of us have got a fair amount of experience interviewing people. So we know that that's a good way to get to people's experience and to really try and understand a process through their lens rather than us trying to impose something on them. So we thought very quickly, well, interviews is going to be a good way to do this. But we wanted to make sure that we captured the experience of people who either had never been to prison or who have been released from prison, and those still currently in prison, because we needed to work out, have things changed? Is there a difference between trying to appeal when you're in prison and trying to appeal once you're out of prison? Are the challenges different? Are they the same? So that was our start point. To be honest, we weren't sure whether people would want to talk to us. It's a difficult subject to talk about. So we just had a strategy of thinking, anybody who's willing to talk to us, who's been through this process, we will try and talk to them, as long as, it's obviously not going to cause them additional harm, as long as they understand what the interview is doing. So we had to obviously be quite clear that we can't help people with their cases. Because we weren't sure whether people want to speak to us, we put out calls via organisations like Progressing Prisoners Maintaining Innocence, by Appeal, and that kind of just snowballed into people approaching us. And we were pleasantly, from a researcher perspective, but shocking obviously from a justice system perspective, we were surprised how many people did contact us. And we pretty much, as I said, interviewed anyone that wanted to talk to us about their case. There was occasions where it wasn't going to be appropriate, but we rarely turn people away. And indeed, though, even when we finished the project, people were still approaching us, and it was really difficult actually to say to them, we have actually finished now, we can't speak to you.
I can imagine.
Yeah.
And you touched upon this very briefly, but how did the experience differ between participants in prison versus those at liberty? Did setting influence their narrative at all?
Interestingly, so people at liberty who had experience of prison were telling us the same narratives as those who were still in prison. And it was, I don't think that necessarily being in that setting for the interview, as it were, affected their narrative. It told us that actually not much had changed. So some of the people we'd spoken to have been released from prison for several years, but the people who were still in prison that we were talking to were raising the same issues. So it showed us that, that there is kind of consistency in this experience, which is really sad for one thing, but also kind of tells us, okay, there are systemic things going on here. This isn't kind of just an isolated incident.
Absolutely. And you highlighted that applicants often lack legal representation. You talked about the legal aid issue. And how did you trace the impact through your interviews, apart from what you knew already from your previous experience?
Yeah, so as I say, my research has always been around legal aid cuts. That was a real key theme for this project. And because we'd done the previous work on how lawyers had reacted to funding cuts in the appeal process and in relation to CCRC, we kind of drew on those findings and asked similar questions to the people that we spoke with in this project. And that kind of allowed us to compare and contrast the experience and see how it played out. And really, most of what lawyers told us was replicated by applicant experience. Although that's kind of predictable, what's helpful, as it were, to have that as a piece of data is that it gets around the argument that you often hear that, well, lawyers are always going to say they need more money. Well, actually, it's not just lawyers saying it, it is people who are on the receiving end. And actually, their voices are the most important here. So it gives a nice, more holistic narrative of the impact of legal aid cuts, which is really what we were looking for. And of course, the amount of lawyers that people had to contact to try and get any assistance, absolutely eye-watering sums of money being requested for any legal advice whatsoever. It's a dreadful state. It's in a real dreadful state, particularly at this end of the criminal justice system.
What were your main findings in that respect?
Significantly, the further people progress through the criminal justice system, the less likely they are to be able to find legal representation. So what we found is that pretty much everyone that we spoke to had been represented at their trial. Then a reasonable proportion of those people have been represented if they've gone to an appeal. And then even fewer of those people, it was a very small percentage of the people that we spoke to have been represented in a CCRC application. So it sort of goes in a kind of shape like this, where it just declines the further into the criminal justice process you get, which is kind of strange, really.
Counterproductive, because it's
Exactly.
the issues are more complex
Exactly.
and more legal, and therefore you would think that that is the time when legal representation is more required.
Yeah. Although I should say, I think legal representation is required, obviously, across the
Of
board.
course.
But it's really troubling that the impression that you're left with is that post-trial, think everything just falls away and people can't get the help that they need. And as you say, these are really complex processes. It is utterly unreasonable to think that most people can run an appeal on their own, and it's also unreasonable to expect lawyers to do such complex work for free, basically.
Absolutely. And this is not surprised the most participants struggle to understand core concept like something new or real possibility. Can you illustrate how their misconceptions surfaced and what that tells us about the CCRC communication?
Of course. So, of the 49 people we spoke with, 35 of those people had actually made an application to the CCRC. Others had given up, to be frank about it. And many of those had never even heard of the real possibility test. And given that that is the basis upon which the CCRC are deciding whether or not to make a referral, I think that is something that you would hope they understand. One person mixed up the test used by the English and Welsh CCRC with the test used by the Scottish CCRC. So they have different levels because it's a slightly different criminal justice system. Others thought that the test was just, well, was the trial unfair? But it's a very, very difficult test, the real possibility test, because it requires the CCRC to try and predict what the Court of Appeal are going to do. And that in itself is very complicated. And of course, that's a difficult job for the CCRC. I don't kind of take issue with that being a difficult process for them, but it's not well understood that this is the role that they have. And people instead tended to think that the CCRC was there to make the decision about whether the conviction was safe or not, rather than as a kind of organisation that decides whether to refer a case to the Court of Appeal as well. And there was just an overall sense of a lack of clarity. So lots of people hadn't even heard of it. If people had heard of it, and we directly then asked, can you tell us what you mean, what you understand that to be? Lots of people just said, I'm not really sure. I don't really know what the CCRC is looking for.
Sorry, do you know if the CCRC goes in prisons or other settings, giving talks, or what they do?
Yes, so they do. Since 2022, they have upped their outreach activity quite significantly. And they do go into prisons and they do provide some basic information about how they work. To be honest with you, I can't remember off the top of my head now how frequently they go, but those sessions are aimed at people who might be thinking about applying to the CCRC. So one of the things that I have suggested, or Amy and I have suggested, I should say, is that actually the CCRC should also hold groups or meetings with people who have already applied, because currently they're targeting potential applicants. And then one of the issues with communication is that those who have actually applied feel like they then don't know what's going on. So I think if the CCRC was able to go into prisons more frequently and differentiate between potential applicants and actual applicants, that might help with understanding. I also think actually that the CCRC could provide more information about the tests that they use and something new at an earlier stage in the process. So I think after they receive an application, it's not until a little bit later in the process that people are sent information about the real possibility test, usually with a decision notice, as I understand it. And actually, they need it before the decision notice. So that's another thing
Absolutely.
I've suggested, that actually they kind of shift the order in which they're providing information.
Those are great suggestions. But just going a little bit back,
Mm,
you draw attention to the CCRC actual application
mm,
form and its accessibility in prison settings.
mm.
What emotive or revealing stories stood out about
Mm.
how people filled it or people who couldn't?
Yeah. So what people said to us about the application form was a real set of mixed experiences. There was a kind of real broad range of experience. The ones that really stood out to us actually came from a lot of women that we spoke with, because the impression that we got was that even with an easy read application form, people lacked the confidence to even attempt it. And this was most often relayed to us by women. So they would look at the form and not really know how they were meant to fill it in or what exactly was being asked of them, and tended to give up. And one person told us they looked at it, they became really frustrated, and just stopped, just didn't even bother, although they maintained their innocence. And that was somebody still in prison. And another told us that if they hadn't had family on the outside of the prison setting to help them, they would have given up as well. People often felt that the form lacked clarity as well. And again, it's a case of individual experience, because others told us that they found the form patronizing and that it was oversimplified. So we had this real gulf of experience with the application form. And I think probably the easy read application form is the best option to try and reach as many people as possible. But there was clearly situations in which people needed somebody, whether that be somebody trained in the prison, whether that be somebody from the CCRC, whether that be a lawyer, to sit down with them and actually go through it and help them fill it in. Yeah, real range of experience there, but it was really sad. They were often quite challenging interviews for Amy and I as well, to not be able to just sit down with somebody and help them and explain to them, hey, this is what the form means, because lots of people were just giving up.
That is very sad indeed. And does it take into account neurodiversity at all?
No, and that was also a common issue that was raised with us, particularly a few people that we spoke to raised issues of neurodiversity and a whole range of neurodiversity points. And so we spoke to somebody who told us that they were autistic, and they said that that means that they want to provide as much detail as they possibly can, and they want to just write everything on the form, even though they know that probably isn't going to help. But without more guidance, they don't know really how to approach the form in the first place. So people could see, oh, the way I'm responding is probably not going to help, but I don't know what else to do.
Let's see. And there are some quotes that I will call shocking, such as a Mickey Mouse mechanism or about as effective as a chocolate fire guard. That speaks volumes. What do they tell us about applicants' expectations versus their actual experiences?
Yeah. So, so you're right.
Can
Those
you give
comments,
us a context? Because obviously I've read it,
absolutely.
but yeah.
Absolutely. And the chocolate fire girl comment has come up lots of times when I've spoken to people. And really, these comments tended to relate to the way that people felt the CCRC performed, or rather necessarily didn't perform, investigations. So oftentimes applicants were asking the CCRC about specific points of investigation. And what would happen is that they put their application form in, they asked for a particular point to be looked into. They didn't hear back from the CCRC in what they regarded as a helpful or a timely way. And then that kind of created an overall sense of distrust in the whole process. So it was a kind of mixture of the CCRC not performing investigations that had been requested, and also not communicating with applicants in a way they understood about why investigations weren't being performed. So this quickly, as I said, led to declining confidence in relation to the CCRC itself, and many people saying to us, we don't think there's any point in applying to CCRC. They won't do what we'd like them to do anyway. And I think this is this dual issue about what type of investigations they are and are not doing, and also about the way they communicate their decision-making processes.
Is it true that most of their review are desktop review? They are not actual investigation, and they rely a lot on Court of Appeal and prosecution documents?
Yeah, so I mean, I have to say, we didn't look at any of the actual work that the CCRC had done on these cases, so I can't kind of comment on whether these were desktop reviews or whether they did conduct any further work. It's certainly a common criticism of the CCRC that it's mainly desktop based now, and that they do rely very heavily on the judges summing up from the original trial. That was something that participants told us a lot. They were really frustrated that they felt the CCRC were just looking at the summing up from the original case and shutting them down very quickly. But very, very few people, it was, I think, one person that we've spoken to had actually had a face-to-face conversation with the CCRC about their application. And that was a real source of frustration, understandably. And I think that is something that needs to be addressed.
One out of the 49 that you spoke to?
Yeah.
Your briefing offers specific recommendations, like clear explanations of concepts such as something new and real possibility, better guidance of unrepresented applicants. What were these recommendations in general, if you can go through a few of them? And which one do you see as most urgent, and why?
We made a number of kind of different recommendations around themes. And the first, and I do actually think this is really the most important, is around legal representation. We think that funding needs to be increased so that more people can access legal advice and make it easier to access legal advice. We also think that the process by which funding is obtained should be made simpler. And also, we think there should be a publicly available directory of lawyers who specialise in post-conviction work, just to make it as easy as possible to actually find reliable guidance, because the overarching theme really is that a lack of guidance where people can just sit down with somebody and talk to them about that case. And it doesn't necessarily need to be a lawyer. As I said, it could be somebody trained in the prison system. It could be somebody from the CCRC. What people seem to desperately need is just somebody to sit with them and explain it in person, answer questions there and then. Lawyers, I think, would be the best place to do it, because obviously they are acting in that person's best interest, where somebody in the prison or the CCRC doesn't have that obligation. But anybody who knows the system, that can just sit down and talk to people. Related to that is like preparing a how-to guide, a booklet that sets out all the stages and what tests apply at which stage as well, we think would be really helpful. The CCRC has produced information booklets and leaflets and flyers that they did share with us for the project, but our view was that they could and should be tweaked a little bit further. For example, I think there should be more diagrams, like a flow chart would be more helpful. The CCRC may follow that up. I'm going to be working on something around that with Appeal over the next few months as well. We're going to try and look into developing a kind of a guide for people in prison that we hope will be useful. But so it's information is really key, and accurate information that can be communicated in person as well. I say somebody sitting down and going through things with somebody maintaining innocence is really, really important. Our other recommendations related to more consistent, up-to-date and accurate information being available in prisons. Generally, we think that there's scope to improve what's online by various organisations. It would be great to see organisations like Citizens Advice have a dedicated page for appeals and for signposting. I know that when I last looked on Citizens Advice website, they had something about prisons, but it'd be good to see them expand that and include some information on appeals as well. I think that'd be a good first point of contact as an organisation. And we also obviously made a number of recommendations to the CCRC about improving their communication style, visiting people, setting up these kind of workshops for applicants in prison, and different ways that they might be able to improve the perception of transparency, because lots of people told us that they felt the CCRC wasn't a very transparent organisation. So we made suggestions around, you could tell people a little bit more about your staffing and who's going to be looking at the case, and be a bit more proactive in terms of keeping people up to date with the stages of an investigation as well.
Great. Those are amazing recommendations. Which one do you think is most urgent?
I think that funding is most urgent. I think that we will struggle to implement a lot of these things unless funding is injected into the system.
You call for the CCRC to enhance outreach, you just said, but especially prison and third sector groups. What might genuine or practical engagement look like in your view?
Well, I think firstly, they should have face-to-face meetings with many more applicants than they currently do. The CCRC currently visits all applicants under the age of 18, people who appear to experience language barriers, or people where they don't understand their application. But we think that they should hold visits and calls with people who make more than one application to the CCRC, women, because they have been identified as a group with particular needs. And anybody who is identified as having additional need, including around literacy issues, and people who repeatedly send large amounts of additional information to the CCRC, because it seems like in that last category, there's just a lot of back and forth. The face-to-face meeting might really resolve a lot of the issues. So we think that there should be more categories of people that the CCRC will implement a face-to-face visit. And as I mentioned before, the workshops for applicants in prison. I do appreciate that's a resource demand, but my sense is that if you can invest the resource at this end of the system in terms of going to see people and hold workshops, it might mean they have fewer kind of long running applications. It might mean that they're able to streamline processes a little bit further if they've actually gone in and spoken to people and people are clearer on what is needed. Because the lack of clarity, people are holding out hope for the CCRC to do something without actually understanding what it is the CCRC needs from them. So I think that can make the process more protracted and therefore actually more resource intensive than if the CCRC just went in and spoke to people.
That argument actually, in my view, calls for a meeting with the applicant at every single application. I mean, they're having what, 1,500 a year. That's 1,500 meetings. But that, I believe, with your argument, will save in the long run communications, letters, misunderstanding. I think it will be time saved. I understand the resource, but once their case manager has taken the case on the first day, actually reading the case and speaking to the applicant. I mean, nowadays a Zoom call, it's not difficult. I see that as a possible, rather than just going for certain individuals.
Yeah, and actually, to just add to that, we conducted most of our interviews online. Even in the prison, so some prisons we did go into in person, but others, for security reasons, preferred us to be online. So it is perfectly possible, particularly with all the resources, the tech resources that we have, to hold meetings like this. And so we held interviews with people up and down the country, from all over the place, because we were able to speak online.
Yes, there is no excuse nowadays. Given criticism around high-profile cases, such as Mr. Markinson, contrasted with some actual good successes, positive cases like the Post Office Horizon, how do your findings intersect with this public scrutiny?
So I think what I would say is most significant in that wider context is that there are many more people maintaining innocence than we ever hear about through those high profile cases. They really are the tip of the iceberg in terms of the number of people who have concerns around their conviction. And we were kind of surprised, as I said, how many people wanted to talk to us about their cases. We didn't actually expect that level of engagement. And so I think it's really important that we don't focus solely on those very high profile cases. And one thing I would really like to do in the future with this work is to write in more detail about some of the cases that wouldn't be considered high profile, offences that wouldn't be considered so high profile, but they tell us something about the criminal justice system more broadly. And I guess what we see is common themes across the high profile cases and the people that we spoke with. Although several people we spoke with had made several applications to the CCRC or for an appeal, they are unlikely to be cases that you would ever hear about in the news media. So I think all of the cases for the people that we spoke with really show similar concerns as you see in the high profile cases, but they tell us that these are not isolated, and these are not only happening in the most serious of offences, they're happening right across the criminal process. Obviously, I can't say, whether the people we spoke to were actually wrongfully convicted, but certainly the concerns are consistent, whether you're talking about post office cases, Mr. Malkinson, Mr. Campbell, if you're talking any of the cases that have hit the news, it's not just isolated to the high profile cases we see in news media. They are similar concerns. They tell us that the criminal justice system has significant issues and there are significant problems in relation to accessing appeals and accessing the CCRC, whether you're a high profile, what we regard as a serious case, or whether you're Mr. Smith who's been convicted of some sort of complex parking issue. Obviously, I've just made that up, but
And just to be clear, the consequences can be as devastating to the single person. I mean, we understand that convictions have consequences, insurance, buying a house, any of those. There are everyday issues that will continue to ruin your existence. So
absolutely. Yeah. And, so many of the people that we had spoken to, that there've been such ripple effect consequences for their family, for themselves, their families, financially, health-wise, all sorts of issues that had arisen, this ripple effect of the conviction. So it's a real bugbear of mine when people talk about minor convictions. Oh, it doesn't matter because it's a minor conviction. No, any conviction has consequences for people, even down to things like traveling. People want to go on a holiday, they can't get a visa, or even things like that. And these consequences are kind of not really well understood. And the mental health consequences were pretty significant as well. There's much more to be understood, I think, about those effects. I think so. There's a little bit of work which I think I know you've engaged with around the impact of having a conviction overturned, but there's not a lot out there in terms of the impact of maintaining innocence and not being able to get your case.
The moral injury that we were talking with Professor Greenberg, it's that moral injury that needs to be looked at much more, and the consequences of that moral injury.
That does only tend to get looked at in the high profile cases where people are kind of prepared to say, oh, okay, this person wasn't guilty, and therefore what's been the impact of this? Well, actually, there's a lot of people out there maintaining their innocence, having those same processes, and not even able to get their conviction overturned. So
your work arrives amid a law commission review of the appeal system. How do you hope your insights will shape that process, and what's top priority for reform?
Yeah, so I've been talking to the Law Commission for a good couple of years now. It coincided us starting this work with the Law Commission announcing that review. And I have to say the Law Commission have been fantastic in terms of talking to us and kind of listening to what we've been finding. In terms of the changes, so the Law Commission can only look at legal changes. So they can't look at changes to CCRC processes particularly. They can only look at things like the statutory tests three things I think come out of that is so I think that the Law Commission, obviously they provisionally proposed changing the real possibility test, which I think is really significant. They have provisionally proposed removing the requirement for something new. They have proposed some changes around the staffing structure of the CCRC, and they've also provisionally proposed extending the 28-day time limit for the
That's
first appeal.
very important.
Yeah.
In 28 days.
I agree.
It's impossible.
I agree. Yeah. So I have, so their provisional proposal was to extend it to 56 days. I have spoken with the Law Commission and said, I don't think that's enough. That's long enough. I think it should be much longer, in fact, because even 56 days is not long enough from all the evidence that we've gathered for people to try and find a lawyer, to work out what the points that need to be raised are, to gather the evidence in support of those points. That 56 days is not even going to be long enough for that. And also there is a restriction on legal aid that somebody can't get a second opinion on an appeal within 6 months of speaking to their first lawyer. So we've also recommended that be lifted. But if that remains in place, well, somebody needs at least 6 months because they have to try and find another lawyer. So I have been talking to the Law Commission further about that proposal in particular. I think it is really important that we change that 28-day time limit. I think that staff, like transparency around staffing, would be really good. And I do think something needs to be done about the real possibility test. I have to say, I'm not entirely sure what it should become, but I think it should become something where the bar is easier to understand. And I think also it would be good to see the CCRC have to refer less to what the Court of Appeal has done in previous cases. Because we know
it certainly shouldn't be a predictive one.
Yeah.
It shouldn't be one that the CCRC should be put themselves in the Court of Appeal shoes. Definitely, but I think that's clear that the Law Commission is supporting that.
Yes.
For definite.
Yes.
In conducting this deeply personal research, you probably used anyway as a defense lawyer, were there moments that particularly challenged or inspired you?
Yeah, so to be very honest with you, although both Amy and I have conducted a lot of interviews as researchers, and obviously me as a lawyer in the past, we both did find it really challenging because there's such a sense of resilience and fight in a lot of the people that we spoke to, which obviously is really admirable, but also it's not right that people have to have that resilience to be able to get it. It shouldn't take that much out of people to have to go through this process. Yeah, Amy and I both underestimated how challenging we would find these interviews. As somebody who is legally trained, it was particularly frustrating sometimes. Obviously, I wasn't able to give legal advice. And so, I couldn't say to people, oh, maybe you should pursue this point. Or maybe, I just couldn't do that in my role as a researcher, which was very frustrating at various points. We were able to signpost people. So I did at various occasions signposted people to organisations that might be able to help. But it's difficult conducting interviews where actually I know what the real possibility test means, but I wasn't allowed because of my role to explain it there and then. I did on occasions try to explain things in a way that might be helpful, but it's hard. It was hard, certainly, at various moments. And also, there is a sense of frustration just not being able to help people. It's quite demanding, actually, to be in that role of having knowledge and not being able to use it to help people is tricky. But hopefully we had to kind of think of the bigger aim. Yeah, we might not be able to help this individual in this moment, but hopefully through the recommendations we can help more people. We can help both the people we spoke with and future, although the ideal is not to be in that position in the first place. But
indeed. And looking ahead, how would you like practitioner, policymakers and the CCRC itself to respond to your findings? And is there a next phase to your research planned?
So practitioners, I think, so we made a number of recommendations previously to practitioners around the way in which they provide information to clients and ways in which they could manage cases, which might be helpful, and also ways in which they engage with the CCRC around giving very clear direction about what's needed and why. So those stand, I would say. Policymakers, I would love to see full engagement in relation to funding, obviously, both the CCRC and for lawyers. I came across, there was a review a little while ago that followed from the Independent Criminal Legal Aid Review, which made recommendations around the CCRC and funding for doing CCRC casework. And I saw something recently which suggested that the government decided there hadn't been sufficient database to actually make those changes. I would really like them to revisit that decision. I would love for policymakers to really engage with the post-conviction criminal justice process more so than they have done. I fear that it becomes forgotten as the final stage of the criminal process. So I would just like a bit more, I would like them to pick that up again and pay some more attention to it. And the CCRC itself, well, hopefully they will make some changes around their communication, their letters, their visits, how they explain their decision making to people that apply to them, and adjust some of the information provision that they have in terms of adding some greater clarity to the explanations they do provide. And yeah, so I think I mentioned already doing some work with Appeal. So partway through this project, Appeal, who people will know obviously represented Andrew Malkinson, and who I've known for a little while, approached me and said that they had also noticed that there was a particular issue with women in prison applying to Appeal or applying to CCRC. So we are hoping to do some work going into the prisons, but we'll do it with people at liberty if we can't go into the prisons, around how do we develop a guide that would actually help people in the prison process to understand and navigate. And it is starting by addressing particular concerns that women might have, but then the hope is that that could then be expanded out to the wider community, both at liberty and in prison more generally. But the aim is that we speak to people again and say, okay, what tools would actually help you?
I can't think of anything that women particularly would have more than others. These are vulnerable, and
yes,
if they're maintaining innocence, they are innocent
absolutely
people and should be applicable to everyone.
Yes.
But it would be interesting to know why they're finding difference from women in particular. I haven't looked into that. Is there a message you would like to leave with our viewers, who might be, some of them, aspiring applicants themselves?
Yes, I would suggest finding support groups. The support organisers like Spoken Injustice, like Progressing Prisoners Maintaining Innocence, although I think they've changed their name recently, like Innocence UK. All of these networks that exist are really vital resources for people who want to inquire and look into appealing their conviction or applying to CCRC. There are resources in terms of signposting information, being able to offer explanations about things, but also knowing that you're not alone. It's really dreadful that we have so many people who maintain innocence and aren't able to find out where to go to deal with that situation. But if you can find these support organisations, if you can learn from other people's experiences, it will not only help you practically, but it's a really vital support group, I think, and that's equally as important. Knowing that you're not alone in this is equally important in many ways.
That is an amazing way to conclude our discussion. Spoken Injustice is here for our viewers to have that support group. It has been a powerful conversation that reminds us that justice isn't just about laws, but it's about people, their lives, and their ability to access the system. Dr. Welsh, thank you for your time and your important work, and for helping us think more deeply about who the system serves and who it lives behind. We look forward to seeing how your findings influence future reform. Thank you.
Thank you, Anna. Thank you.
Bye.
The Criminal Cases Review Commission plays a crucial role as the last hope for many who believe they've been wrongfully convicted. But as Dr. Welsh's work powerfully shows, if people can't understand the process, can't access legal support, or feel ignored by the system, then justice becomes a distant concept, one available only to the few, not the many. Today's conversation reminds us that reform isn't just about changing institutions. It's about making sure that everyone, regardless of background or circumstance, can meaningfully engage with the justice system. If you're interested in reading Dr. Welsh's full report, this is linked in the description below. And I hope we can keep the conversation going in the comments. I look forward to hearing your views. As always, like, share and subscribe, and join us again as we sit and rise in this unique trial.